Are dangerous high school sports drills protected from liability? To find out, you have to read Grady versus Chenango Valley, but it's 42 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, New York Court of Appeals cases in 5 minutes or less. I try to. This is the case of Grady versus Chenango Valley School District, published by the New York Court of Appeals on April 27, 2023. The citation for this case is 2023 New York Slip Opinion 02142. And the issue in this case is the application of the primary assumption of risk doctrine for sports practice for high schoolers. Now, what are let's talk about the law you have to understand to appreciate what's going on in this case. There's basically two things you have to know. The first is that in 1975, New York changed from a contributory negligence state to a comparative negligence state. And in 1975, they passed CPLR 1411, which is a statute in the Civil Practice Law and Rules. And that is essentially a statutory effect. It's a statute that applies that comparative negligence, which says that instead of if the plaintiff is 1% responsible for the accident, then the case can be dismissed. That's what contributory negligence used to mean in actuality. Now, what comparative negligence says is that when we get to the damages phase of an action, then the jury, the finder of fact, is allowed to consider the amount that the plaintiff contributed to the incident and the amount that the defendant contributed to the incident, even with respect to assumption of the risk or contributory negligence. And at that point, the jury can say, well, the plaintiff is 51% responsible, so we're going to not give any damages to the plaintiff. Okay. And the other aspect is after 1975, the New York Court of Appeals in subsequent cases kept applying assumption of the risk in limited circumstances limited to sports and recreational activities. And the thought process was, well, these are socially beneficial, but they involve heightened risk. So if we were just to apply regular comparative negligence even to sports and recreational activities, then we'd be basically making these things uninsurable. Who would ever want to be a little league coach if you can get sued all the time? That's essentially the concept. So what are the facts in this case? Basically, both these cases, this is two cases combined for appeal. One is called Grady versus Chenango Valley. Another one's called Secchi versus New Paltz, both school districts. And the first one is a baseball case. The second one's a basketball case. In the baseball case, the baseball coaches had a drill where they were basically throwing multiple balls from different areas of the field towards first base, and the first baseman gets hit in the side of the head with a baseball and he's partially blinded. In the second case, in the Secchi case, which is a basketball case, the basketball coach has a drill where they're trying to have the team work on being aggressive with rebounds. So the coach says, you know what, for this particular drill, there's no out of bounds, and I'm only going to call major fouls. And obviously, this drill becomes very, aggressive, and one of the players gets bumped in by another player into the bleachers, and his shoulder's injured. So the parents sue. Going to the procedural history of this case, in the Grady versus Chenango Valley School District, there was a motion for summary judgment based upon the primary assumption of the risk. Like we talked about, you can move to dismiss the case if it's a sport or recreational activity, and the Supreme Court denied the motion, but the appellate division reversed. And in the Secchi versus New Paltz Central School District case, there was a motion for summary judgment based on primary assumption of the risk, and the Supreme Court granted the motion. Okay, and the appellate division affirmed. It goes to the Court of Appeals, and now we have the holding. The holding of this case is an application of the rule, saying that the primary assumption of the risk is an exception to comparative negligence. And they reaffirm the reason. They say that the reason why we have this is to allow this socially beneficial but inherently dangerous activity. And they say they kind of give the elements of what needs to be present for there to be a primary assumption of the risk. And it's consenting participants in a qualified activity that's aware of the risks, has an appreciation of the nature of the risks, and voluntarily assumes the risks. If all those are present, and the qualified activity is a sport or recreational activity, then the defendant can move for summary judgment based upon this theory of primary assumption of the risk. And they make a point to say that the plaintiff doesn't have to foresee the exact way the plaintiff would get injured, but simply the mechanism for the injury. So if a baseball player knows the ball's being thrown around, then he knows the mechanism, and if he gets hit by a baseball, he's aware of the risk. But they say the primary assumption of the risk does not apply when the risks are concealed or unreasonably enhanced. And that's the case. They apply these rules to the cases at hand, and they say that they basically apply them to both cases and say that in Grady, there was tribal questions of fact as to whether the baseball drill was unreasonably enhanced in terms of danger. But in Secchi, it was not unreasonable. Taking away the boundary lines was not unreasonable, and therefore summary judgment was proper. But I will note there was two dissents here, a dissent from Judge Rivera, and she says this whole primary assumption of risk should be thrown out. CPLR 1411 says that assumption of risk is included in 1411, that it should be comparative negligence for the entire state. And there should not be an exception for a primary assumption of the risk. So she would throw both these summary judgments out. And finally, there's a dissent by Judge Singas, and she reaffirms the majority mostly and says, and reiterates the reasoning and says, it's easy for UBS Arena or for Citi Field to insure these sports because they have a lot of money. But think about like the youth leagues or the religious organizations or the disadvantaged local organizations. They don't have the money to insure these youth and sports leagues. And that's why it's important that we have this primary assumption of the risk. And that's the case of Grady versus Chenango Valley. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.